Hello people, this is Mark with you all today. As you know, this is Mark with you all today, and today I'm going to be showing you some pretty interesting stuff. I'm going to be showing you just how ignorant these attorneys are in Columbus and just how much they abuse the process. And I'm going to work this video all the way up to a strong point in what's happening, today, and why it's important that we have a constitutionalist in the United States Supreme Court. I'm going to pretty much expose their little scam that they have running on in the country right now. And from what we gather, the scam that they have running in Ohio, which is going to be exposed. Now today, what I'm going to start with is as you know, we had a lawsuit against all these people who did all of this, committed these acts towards my brother Moses and myself. Now we had the judge Michael J. Holbrook, and he tried to help out his compadres, and he basically turned our civil conspiracy case into a legal malpractice case, and he tried to reduce it down as much as he can to help them, but the shenanigans didn't work. He didn't know the bulls that he were up against. Okay, now what we're looking at here is the appeal that was filed. Okay, this appeal was filed on 4/20. This appeal was filed on 4/20. Okay, now 4/20 of 2018. All right, so when he issued his order in the situation from the lower court case, the civil case, this is the same judge who said, "I don't care what law books you read." So, pretty much he was trying to help his friends out, and we can kind of understand because you work with them every day, and, we kind of understand, but you're not going to be doing that to us, okay? You got to do it's very important to do your homework before you think you're going to bombard and try to do some fancy stuff on someone, which by the way is not fancy at all. They look like children. Now what we're looking at here is the appeals case, and this is the appeals case ending in 284 18-AP-000284. Okay, now what I'm going to point out to you guys is that this was an appeal that was filed, and these are all of the parties pretty much. Okay, these are all of the parties pretty much in the appeals. Okay, those are all the parties. Okay, now when we appealed this, what he went on ahead and did is he set trial for a malpractice suit against one of the defendants by the name of Catherine White. So he took all of the 15 defendants and he basically threw the case out to them, and then said it's only a legal malpractice case for Catherine White, even though we had affidavits on file, even though we've provided evidence, we provided supporting documents, we have sworn affidavits where we swore under penalties of perjury, and yeah, all of that was just ignored. Okay, so that's another form of abuse of process. He didn't have the elements and the facts necessary to support his ruling. He just made a ruling because he was, he didn't care what law books we read. So, we were going to appeal that, definitely. So we definitely did appeal that. Now, that's this case ending in 284. Now, what I'm going to point out to you is that, let me see, what I'm going to point out to you here really quickly here is how stupid these attorneys are and how they're not reading. They're just doing things. They're just getting on the phone, talking to each other, and they're just doing things. They're not paying attention to the the documents that's actually being filed, because see, they're so used to being paper gangsters and paper pushers. They're just putting whatever they need to put on the paper, and they already have everything pre-decided what they're going to do. And it doesn't matter what's on the paper, or it doesn't matter what's filed, because they do this. They have their own little organized system going on here. Now, as I stated earlier, this case was filed on April 20th, and we filed more affidavits. Okay, here's an example of an affidavit we filed. I'm going to read it to you. Okay, this affidavit says, State of Ohio, County of Summit, personally came and appeared before me, the undersigned notary, the within name, Moses McCormick, who is a resident of Akron, Ohio, and makes this his or her statement and general affidavit upon oath and affirmation of belief and personal knowledge that the following matters, facts, and things set forth are true and correct to the best of his knowledge. A judicial notice was filed onto the lower court case number 17 CV 003086 on May 2nd, 2017, and the lower court ignored the precedent therein. All matters and all defendants related to the case are demanded to be remanded back to the lower court by both plaintiffs. The current court orders issued by Judge Michael J. Holbrook are legal nullities and are not in compliance with both the State of Ohio Constitution and the federal U.S. Constitution. Appellant plaintiffs invoke all inalienable rights herein, just as they did in the lower court. Dated this 14th day of September 2018, signature of Moses McCormick, and this was notarized in front of a public notary. Public notary is Noah McFerrin of the State of Ohio, which is an officer of the court, by the way. Okay, and this is the judicial notice that was filed. All officers of the court for Franklin County are hereby placed on notice under authority of the supremacy and equal protection clauses of the United States Constitution and the common law authorities of Haynes versus Kerner, 404 U.S. 519, Platsky versus CIA 953 F2D.25, and Anastoff versus United States, 223, F.3D 898, 8th Circuit, 2000, relying on Willie versus Coastal Corp 503 U.S. I'm not going to go all the way through this, and it also has Trenzi versus Pagliaro in there, which states that you cannot grant a motion to dismiss or a motion for summary judgment against a pro se litigant without the pro se litigant having a chance to enter evidence at trial. Okay, it says in Platsky, courts err if the court dismisses the pro se litigant. Defendant is a pro se litigant without instructions of how pleadings are deficient and how to repair those pleadings. So basically, in regards to Platsky, the courts have to tell us how the complaint is deficient and give us a chance to amend the complaint to correct those deficiencies before they can just throw that out, only if that case law is cited. Now, if Anastoff versus United States or Trenzi versus Pagliaro is cited, statements of counsel in their briefs or their arguments are not sufficient for a motion to dismiss or a motion for summary judgment. Trenzi versus Pagliaro, DCPA 1964-229F. You see. Now, we're going to talk more about that. What they went on ahead and did was they entered a motion to strike that. They asked the appeals courts to strike that because they don't want that on the record. They don't want that to be considered. That means they don't want the appeals court to allow us to invoke our constitutional rights. Now, you know that all the appeals panels judges, they also have an oath to the United States Constitution and the state constitution. So they didn't want that on there. So what they went on ahead and did, as you can see, they put a motion to strike on September 24th. Okay. On September 25th, the motion was granted. Right the next day, How about that? Right the next day? We're not getting any of our motions granted right the next day. They see what they're doing is they're abusing the process. So they're trying to stall us out and things like that. So what they did was they granted the motion, so they striked the judicial notice to tell they strike the judicial notice that informs the appeals court that the lower court was under the common law authorities of Kerner versus Haynes and Trenzi versus Pagliaro. So they moved to strike that because they don't want that in there. Now, courts are supposed to look at the constitutional matters primarily. Okay, primarily. Now they strike that. Now, like I told you, the court case was moving forward in the lower court case, which Michael J. Holbrook was the judge over. That case, he went on ahead and tried to set that for trial as a malpractice case. We wasn't having it because this is civil conspiracy and they're trying to cover it up. There will be no cover-ups. Like I said, we'll fight this thing until I'm 99, and then if it's still going, my children will fight it. Okay, so we're not having it. Okay, it's hammer time. So with that being stated and with that being understood, they entered the motion to strike. The court granted it right the next day because they really needed to get that off their record. Oh, we can't. Yeah, we have to get rid of this. This is not good. He had Michael J. Holbrook's court under judicial notice. He invoked constitutional rights on the record. Oh, let's strike this. You know, I don't know who the hell they think we are, but so that's in this appeal case. Now, what he turned around and did was the case that he set for trial for Catherine White. What we did was she entered a motion for judgment on the pleadings, basically asking for a motion for summary judgment to be granted, even though the court is under those authorities, those judicial notices. Okay, so what Michael J. Holbrook did was he turned around and ignored it again, which, by the way, is a violation of his oath of office. The oath of office is a contract stating that anything about the Constitution that's talked about, anything that's regarded with the Constitution will be paid attention to primarily. Okay? He said, oh no, fuck that. I don't care what law books they read. I'm going to do this. They don't know. Okay? So what I'm going to show you on this next tab is we filed an appeal on that. So he issued an order. Okay? He issued an order for that case. And we filed an appeal on that one. And that is this appeal right here. This appeal was filed August 27th of 2018. This is appeals case 18-AP-0000650. Okay, now this appeal, I'm gonna break something down to you. I'm gonna show you the incompetence of these attorneys and how they play games and how they're abusing the process. Even the appeals court finally caught on to their shenanigans, and I'm gonna show you what the appeals court panel judges put together. Okay, now, I mean, because it just got out of hand at this point, so they had to go in there and tell them this is ridiculous. Now, this was the order granting Catherine White summary judgment. Okay, this is the order granting Catherine White summary judgment. We appealed that order, okay, because she needs to be remanded back to the lower trial court with all the other defendants in the other appeals case, and it all needs to be moved forward as a civil conspiracy case, and we need to be allowed to bring our evidence in and let us prove our case and let a jury determine what it is. Okay, that's what they try to stop. They try to make the decision for us. They try to control our liberties, but we not having it. Okay, now as I scroll down here, this shows you that this appeal was filed August 27, and this is the judgment that we appealed. I'm going to open it up very quickly here. Okay. Decision and entry granting defendant Catherine White's motion for summary judgment. Okay, filed June 6, 2018. This matter comes before the court upon the motion for summary judgment filed by defendant Catherine White on June 6, 2018. Therein, defendant seeks judgment in her favor as to plaintiff Moses McCormick's sole remaining claim against her for legal malpractice. Plaintiff has not filed a responsive memorandum, thus defendant's motion is unopposed. Plaintiff, as well as his brother, Mark McCormick, initiated this action by filing a complaint against defendant, among others, for negligent, abusive process, intimidation, and intentional infliction of emotional distress, malicious prosecution, fraud and forgery, defamation, slander, etc., etc. I'm not going to read this whole order, and we didn't feel a need to respond to her motion for summary judgment because he already ruled that the case was a legal malpractice case. He made that decision. He made the decision. He threw out all the other charges and said, well, I only see this as a legal malpractice case towards Catherine White. So what he did turn around is he turned around and contradicted himself. He turned around and contradicted himself and granted her motion for judgment on the pleadings, basically giving her a motion for summary judgment. He ignored the judicial notice that was filed. Okay, the judicial notice that I was just talking about that was filed on the record, he ignored that. He said, fuck the Constitution. He said, fuck the Constitution. This is what I do. Okay? That's what he said. That's what he said. I don't care what law books you read, and I don't care. He didn't care. He did what he wanted to do. And that's what's going on in this court, and that's what's going on in a lot of courts. And that's why a lot of people are not getting the justice that they need, because they don't understand that the Constitution is the contract and is the agreement that uphold their rights to give them the ability to go in there and challenge anyone in front of a jury, regardless of how the judge feel. Okay? As long as those rights are invoked in a timely manner. Now, getting back to this, this is pitiful. This is organized crime. This is crime. This is crime. This is treason. This is encroachment. This is raggedy. These people are no professionals. Okay? These people are very deceitful. Okay? And all constitutional rights invoked now waived. Alright? So as you can see here, this thing got so ridiculous, it got so nasty, that these people, the defendants that is in the other appeals case that I just showed you, they filed motions on this appeals case. They filed motions on this appeals case when they weren't even parties to this appeal. Okay? They were not parties to this appeal. Let me show you. Let me show you here. It's disgusting. It's disgusting. This is the notice of appeal right here. This is the notice of appeal. Okay? Look at this. This is the notice of appeal. This is appealing for the judgment entry from July 31st. Okay? Okay? And as I showed you, the judgment entry from July 31st is only for who? Catherine White. Right here. Decision and entry granting defendant Catherine White's motion for summary judgment. Okay? All right? This order went in July 31st. Okay? At noon 50. All right? Okay. So now that I outlined that clear for you, let me tell you what's sad. Let me tell you why these people are no professionals. Okay? These people are no professionals. Look at what they did. Now, when you go up here to the top, they all filed. They're not even parties to this appeal. And they came in and they filed motions to dismiss on the 24th, the 26th, the 27th, and the 28th. Okay? These parties all filed motions to dismiss. They're asking this court to dismiss them from this appeal because they're saying that they're already a party to another appeal. Okay? Where are they getting that information? What compelled them to do that? What compelled them to enter a motion to dismiss on this second appeals case towards Catherine White? Their name is not on a certificate of service. Their name is not attached to that order that was attached to this. The point that I'm outlining to you is that these people are not reading. They're making phone calls and just putting shit on the paper. And this is the abuse that we've had to go through all of 2017 and all of 2018, okay? All of 2017 and all of 2018. These cases is on an accelerated calendar, both of them, and we have had no oral argument for it yet. The appeals case that was filed April 20th, it is now October 21st and no decision for an oral argument. No, we requested oral argument. That's more abuse of process, okay? All right? Okay, this is what they use on people. This is how they deny your justice. This is how they thwart your process, okay? This is how they thwart your process. But we going to get that Ohio Supreme Court and Maureen O'Connor, we going to get them together. And they going to cut this shit out. Look at this shit. Look at this. When you go into here, let me show you what the panel judges said in this. Let me show you what the judges said. The judge entered a order. The panel judges entered an order on October 2nd, this month, okay? Let me read to you what that says. I'm going to make it big, too, so y'all can see it real good. Okay? Now, I'm going to show you. These people are pitiful. They need to get their refund back from their law school.
Wasted a lot of money.
Because they got their mouths ripped out. Look at this. Look at this. Look at this shit here. If this ain't shenanigans and criminal activity, then I don't know what is. They furthering evidence that it's a civil conspiracy. Listen at this. Listen at this. Journal entry, okay, in the Court of Appeals of Ohio 10th Appellate District. I am so embarrassed. I'm so embarrassed. Okay. It says, it appearing that the sole parties in interest to this appeal are Appellate Moses McCormick and Appellee Catherine White. The clerk of this court is ordered to discontinue mailing to all other parties and their counsel of record in this appeal only. Okay? Accordingly, the September 24th, the September 26th, the September 27th, and the September 28, 2018 motions of the appellees Rosemary Welch, Hendretta Scott of Franklin County Department of Job and Family Services, Franklin County Child Support Enforcement Agency, Deputy Clerk Steve of the Ohio Supreme Court, Sushan Liu, the Columbus Police Department, Stacy Gilbert's crooked ass, and the law office of William Geary to dismiss them as parties to this appeal are moot, and we decline to address them. The clerk shall note the docket. Now, people who don't understand legal lingo, let me break that down and tell you what that's saying. Basically, the panel judges is saying, what the fuck? What the fuck y'all filing motion to dismiss for? And when I say y'all, I mean the attorney for Rosemary Welch, the attorney for Hendretta Scott, the attorney for Franklin County Department of Job and Family Services, the attorney for the Franklin County Child Support Enforcement Agency, the attorney for the deputy clerk of the Ohio Supreme Court, and the attorney for Sushan Liu, and the attorney for the Columbus Police Department, and the attorney for Stacy Gilbert. And Stacy Gilbert is an attorney herself. And so is Rosemary Welch, okay? And the law offices of William Geary. So that's telling you right there, they don't know what the fuck they doing, because they're not reading anything. They're not reading, they're just doing shit, okay? They're just doing things. And yes, I'm being a little bit vulgar in this video this time because it need to be said because I'm pissed the fuck off. Okay? This need to be said because this is ridiculous. You have children wanting to grow up to be attorneys, and this is what they're going to fall into. This is what they're going to fall into. Okay? This shit going to get stopped. This is not real. The panel judges declined to address them and called their motions to dismiss moot because the panel judges is saying, why the hell are you guys filing motions to dismiss in this case? You're not a party. You're not parties to this case. Because they're not reading. They don't care what the paper says. Okay? If you go through if you go through the videos that I said, that's titled, the judge said, I don't care what law books you read. He don't. And neither do any of the attorneys because they already have what they're going to have set. And then they go in those courtrooms on the record talking all of that fake legalese shit, trying to sound smart. And it's all acting. They're taking orders. Okay? They're thwarting people's processes. As you see here, our processes are being thwarted. The first appeal case was filed 4/20, and we still haven't been in front of panel judges for oral argument or anything. Okay? This is what they're doing to people. And thank God we don't have an attorney where we're paying. Imagine if we were paying for this, and they're fucking around like that. You see how detrimental that is?
That's one of the big reasons why they're doing that, because we ain't paying no money.
Yes, abuse of process, and this is the disrespect that they have for the pro se litigants. They have a tremendous disrespect for pro se litigants because they want you to go get an attorney because those attorneys is bound to the authorities of the state law. When you're a pro se and you're an individual, you have rights protected by the Constitution, the federal Constitution, the U.S. Constitution, and the state Constitution, whatever state you in. And those judges have an oath to it, okay? That attorney is not going to go in there talking about constitutional rights because he have to continue to feed his family, and they know that. So guess what that does for you? That says screw you, okay? That says screw you, the represented party that's represented by the attorney. So because we were smart enough to go in there and we understand all of these processes, you know, you can't pull the wool over us, okay? You can't do it. So we understand this. And they're mad. They're just doing shit. So this is complete and total embarrassment. And this is why it's important for the United States Supreme Court of America, the U.S. Supreme Court. This is why it's important for them to have panel judges in there that's constitutionalists, okay? So when you file that cert petition, and they see that you're complaining about constitutional matters, they bring it in there. Okay, it's time for us to talk about it. But if you don't have the right panel judges or sitting in those seats, okay, then a lot of times that won't get done and people are deprived of their right. You have people whose rights were genuinely denied, genuinely ripped apart, genuinely raped of their rights, okay? And they didn't get the remedy that they needed because their cert petition was denied. And so they just have to walk away quietly, okay? After all this money is being spent. This is why it's so important to understand what's happening in the United States Supreme Court right now, okay? This is the whole reason why they want Brett Kavanaugh in. Because Brett Kavanaugh is a constitutionalist. A constitutionalist is going to acknowledge those rights that you invoked on that record in a timely manner. Okay? Very, very important stuff. Anybody that's ever going to be in front of a state judge, whether it's for divorce matters or child custody matters, anything, it all relates. And if they're not doing the right thing, that matter will eventually have to go to the state Supreme Court, okay? And a lot of times the state Supreme Courts are helping their man. So then after that, it has to go to the United States Supreme Court, okay? And that's why it's very important for the United States Supreme Court to have constitutionalists there, because they're going to look at your rights primary. Okay, when that's not being done, then these judges will be allowed to do what they want to do. Okay, this is going to be stopped. This is a new day. This is going to be stopped. This is what's going on. So getting back to the subject at hand, this journal entry that you're looking at right now, okay, this judgment entry is saying that your motions to dismiss that you filed for all of these parties is moot. And we declined to even address them because it's so embarrassing. It's embarrassing. You obviously didn't read the paperwork. And that's why the panel judges says it appearing that the sole parties in interest to this appeal are Appellate Moses McCormick and Appellee Catherine White. So in other words, why the fuck are you other people filing motions to dismiss? You see what I'm saying? This shit gonna get stopped. This shit gonna get stopped. We their worst nightmare. And we never gonna let it go. Never. Never. Never.
Yeah.
Never. Never. Money can't fix it now. Money can't fix it. Money can't fix it.
It got worse.
Money cannot fix it. Money cannot fix this. Okay? Okay? Okay, we want pain.
What about that K they put next to your name?
Yes. And then they were on our channel watching the videos when I say, okay. Okay. And they put that in the paperwork. They put my name as Mark McCormick. These people are sick. They are no real lawyers. Okay? They are no real lawyers. And everyone involved in this, everyone, I mean every single one, we know all of you. We have you. We have all of your names. We have everything that we need. So I hope it was worth it. I hope it was worth it. These courts down there are perverted and they will be stopped. They will be stopped. This stuff is a violation of the 14th Amendment. Okay? They're trying to control our right to trial by jury as well. You can't control that. You don't have that kind of authority. Okay? So I'm not going to drag this video out any longer, but I wanted to show you that these people come onto this channel, hide behind erroneous, they're hiding behind mocked profiles, okay? Putting their little comments down, trying to make us look like we don't know what we're talking about and doing. And clearly, they don't know what the hell they're doing, just like they didn't know who the hell they was messing with. Okay? I hope it all was worth it. Because your names ain't gonna be shit when we get done with ya. Ain't gonna be shit. Your name ain't gonna be shit. Everybody gonna know your face and your name. They will. So good luck. I hope it was worth it. I hope it was worth it. You pitiful piece of trash excuses. How is the attorney for the Ohio Supreme Court yeah, that place is going to it needs to be cleaned out and dipped in vinegar. Okay? Yes, it will be cleaned out and dipped in lemon water and vinegar. Okay? All right. Well, I'm not going to hold this video up. We going into 34 minutes on this video. But yeah, that's why the United States Supreme Court, okay, for those who don't understand why they made so much fuss about Brett Kavanaugh, you know, why they want to bring up things from old things that from what I gather, it's not even credible and it's not even real. They don't want that constitutionalist in that court because they know shit like this won't be able to go on no more. This shit going on all around the country, I'm sure. Okay? Because they got a little scam going on For a long time, it's time for the honey hole and the loopholes to be closed. Yes, they are. Yes, they are. Yes, they are. It's going to be a lot more of us. A lot more of us, American citizens. Black American citizens, white American citizens, Spanish American citizens, Chinese American citizens. It's going to be a lot of us kicking ass. Okay? Now, and like I said, all constitutional rights invoked, none waived. So suck on that.